Enga mana, enga reo, enga reo rangatira, o ngā hoa whā, tēnā koutou katoa. Ko rauto tōku maunga, ko teimā tōku awa, ko Cornwall tōku whenua tipuna, ko Bryony James tōku ingoa. Tēnā koutou, tēnā koutou, tēnā koutou katoa. I'm Bryony James. I'm the provost here at Te Herenga Waka, Victoria University of Wellington. It's my great pleasure to welcome everybody. So welcome, Chief Justice, Your Honours, law faculty staff, friends of the law school and the university. Welcome to the Law Faculty's Cooke Lecture. This has been held annually in honour of Robin Cooke, Lord Cooke of Thorndon, since 2000. Previous Cooke Lectures have been given by judges and academics from around the world, and this evening's lecturer, Lord Sales of the United Kingdom, is a very distinguished addition to that number. The subject of the rule of law is topical at any time, but in our slightly chaotic world, it feels particularly relevant to be hearing about that this evening. The Cooke Lecture is the last formal event of the Law Faculty's year. So welcome to this celebration of the end of the academic year. And I thank you all for coming also to celebrate Lord Cooke's legacy. So I'd first like to acknowledge those who have passed since the lecture last December, especially Lord Cooke's wife, Lady Annette Cooke. I particularly welcome here this evening their sons, Justice Francis Cooke and Philip Cooke, and their families. We thank you very much for your generosity in allowing the Cooke Lecture to continue. So I am the provost here, and Justice Joe Williams has already asked, what does a provost do? Nobody's entirely sure, to be fair, and I kind of like it that way. I do assume there is an antivost somewhere in the university, and we should never meet. But my role of provost is really to look after the academic half of the university, which gives me the great pleasure of working with all 8 faculties, soon to be 6 faculties, so I'm doing myself out of a little bit of fun. And I get to work with all the deans of Te Herenga Waka. Now, I joined Vic a little over 1 year ago, and from the very day I started, it was clear that the law school here is something very special. A fact that the new Dean of Law never misses an opportunity to remind me of. But here in the heart of the judiciary and adjacent to the seat of government, how could this particular law school be anything other than very special? It has a long tradition of excellence in research and in teaching, and I am looking forward in my role of provost to watching it climb to ever greater achievements. Even during 2024, which was an incredibly challenging year for the entire university sector and this university particularly, even during that year of challenge, the staff continue to gain excellent accolades and deserved recognition. And I congratulate all the staff for their achievements this year. As an illustration of the sheer velocity of achievements in this faculty, Professor Maclay provided me with a snapshot of a mere 24-hour window at the end of November. And during this 24-hour window, Dr. Luke Fitzmaurice-Brown received the Royal Society's Early Career Research Excellence Award. Dr. Ruping Yi gave a presentation on her book on Indigenous land rights to the National Library in Taiwan. Dr. Mele Tupou spoke in the debating chamber to a conference of Pacific parliamentarians. This was all within 24 hours, all whilst, and as a provost, I'm particularly pleased to see this, the faculty staff released thousands of exam grades. The challenging times for universities are not over. It would seem that almost daily there appears to be another threat to us fulfilling our role as critic and conscience of society. But I have incredible faith that the faculty here is ready to face those challenges. And to their number, I'm also pleased to be able to welcome the law school's newest professor, Professor Fiona MacDonald, an expert in public health law, who is here in the audience tonight. And in addition to Professor MacDonald, the law school has welcomed or is about to welcome 4 other new colleagues. The law faculty is going and will continue to go from strength to strength. Our speaker tonight, Philip Sales, has had a peerless career, both as a barrister and now as a judge. He studied at Cambridge and at Oxford, and from 1997, he was the first counsel to the Treasury, affectionately known as the Treasury Devil, and the UK government's principal advocate. In that role, he appeared in many of the most controversial cases in the UK for a decade. He was made a QC in 2006 and High Court Judge in 2008 and Court of Appeal Judge in 2014. And since 2019, he has been a judge of the United Kingdom Supreme Court. He is well known as a legal thinker and as a lecturer, and I very much look forward to hearing what he has to tell us this evening. Thank you very much. Thank you, Lord Sales.
E nā iwi e tōne, te nā koto, te nā koto. I mean no disrespect by acknowledging in the language of my ancestors rather than theirs, the muna whenua of this place, te ati awa. Indeed, given my facility in te reo Māori, offering my greeting in English is the most respectful option. In any event, te ati awa, I ask that you, whose fires of occupation and authority burn brightly still in this place, make my wife Miranda and me welcome among you. Te nā koto. I acknowledge also those who have passed beyond memory's horizon, for when we, their descendants, gather, so too do they. Haere nā mute haere. No re ra te nā tato katoa. Good evening, everyone. I want to say blame the pupil, not the teacher, for any mispronunciation. It's a privilege to be asked to give this year's Robin Cooke Lecture. Lord Cooke's unique career as both a judge in New Zealand's appellate court and in the United Kingdom's House of Lords has meant that both countries share the benefit of his remarkable contribution to the common law. In New Zealand, he was instrumental in shaping a distinct jurisprudence that departed from English law, whilst also recognising the importance of our shared common law heritage. Part of this shared heritage is that the rule of law is a fundamental constitutional principle of both our legal systems. The rule of law's importance is recognised in the respective Acts of Parliament that created the UK Supreme Court and the New Zealand Supreme Court. In the UK, Section 1 of the Constitutional Reform Act 2005 states that nothing in the Act affects, quotes, the existing constitutional principle of the rule of law. Similarly, Section 3 of New Zealand Supreme Court Act 2003 stated, nothing in the Act affects New Zealand's continuing commitment to the rule of law, a formula repeated in Section 3 of the Senior Courts Act 2016. But these statutes leave unclear what exactly it is that they do not affect, as neither seeks actually to define the rule of law. This is no doubt due to the controversy surrounding the numerous attempts to provide such a definition. As Jeremy Waldron has observed, the rule of law is an essentially contested concept, with academics, judges, and lawyers engaged in never-ending debate about what it does and does not mean. In my view, the debate reflects a creative tension between different values at the heart of the concept. To understand what is at issue in the debate, it is desirable to strive for conceptual clarity regarding those sometimes competing, sometimes mutually reinforcing values. Given the difficulties associated with the concept of the rule of law, the question posed by the topic of my lecture, what is the rule of law and why does it matter, constitutes a challenging inquiry. But the importance of the rule of law and its centrality in the functioning of modern liberal democracies like those of the UK and New Zealand mean it is an inquiry well worth pursuing. I make no claim that I will resolve and put to rest this debate. It has been going on for thousands of years. But in this lecture, I hope I can make a thoughtful contribution to it from a particular judicial and jurisdictional perspective. I contend that the concept of the rule of law has particular importance in the legal systems of the UK and New Zealand because they lack written constitutions, which is unusual in the modern world. Without a set of codified rules, a reference to general background legitimating principles is necessary in order to create a normative framework for the conduct of public affairs, which transcends a purely descriptive account of power relationships. In the late 19th century, the British jurist A.V. Dicey offered the sovereignty of Parliament and the rule of law as two of the fundamental legitimating principles of the UK's unwritten constitution. And these principles continue to play a fundamental role in our legal systems. A realistic account of the rule of law has to recognise that it is not one thing. The concept of the rule of law is based on a cluster of ideas, the importance of which spans economic, political, and moral domains. I will argue that what is often referred to as a formal conception of the rule of law has substantive and significant value in itself. It provides a minimum content for the rule of law, which should command our loyalty, even if one does not regard the concept as justifying or committing us to thicker versions of it involving a greater substantive set of principles. As I will explain, I by no means rule out the potential viability or defensibility of more substantive versions of the rule of law. But the more substantive the interpretation given to the concept, the greater the tension with the other foundational pillar of the Constitution, namely the democratic principle which underpins the sovereignty of Parliament in its modern instantiation. How that fundamental tension is resolved in any given polity depends on the political and legal culture of that polity. The basic question is, what substantive content of law and what forms of decision-making secure legitimacy for governance structures in that society? There is no simple a priori legal answer to that. I will begin with an account of the formal conception of the rule of law and the benefits associated with it. In the economic domain, a formal conception of the rule of law provides solutions to collective action problems, a response to the tragedy of the commons, and fosters the predictability and certainty necessary to incentivize economic investment. In the political domain, it is essential both for the construction of political authority and then to give effect to democratic choices made by Parliament. In the moral domain, a formal conception of the rule of law respects the dignity of individuals and allows them to exercise agency under conditions of personal responsibility. I will then turn to examine the ways in which the rule of law concept has a real-world impact in the case law of both the UK and New Zealand. These cases show how tensions arise both between different aspects of the rule of law itself and between the rule of law and other constitutional principles, particularly parliamentary sovereignty. So what is the rule of law? The starting point for many discussions about the rule of law is a division of theories of the rule of law into two categories, formal conceptions and substantive conceptions, or as it's sometimes put, thin as opposed to thick conceptions. Paul Craig argues that formal or thin conceptions of the rule of law only require the law to have attributes which do not determine the content of the law, at any rate beyond a fairly minimal level. These are contrasted with substantive or thick conceptions of the rule of law, which hold that the rule of law requires certain substantive content of the law, such as conformity with human rights. Lon Fuller's conception of law is often seen as an exemplar of the formal conception. In his book, The Morality of Law, Fuller offered 8 principles that he argued were constitutive of the law. There must be general rules rather than ad hoc decisions or commands. The rules must be publicized and available to those who are expected to observe them. They must be of prospective rather than retrospective effect. The rules must be clear and intelligible. They must not be contradictory. They must not require the impossible. The rules must be relatively stable across time. And finally, the implementation of the rules by officials must accord with the rules as they have been published. The unifying aim for all these principles is that the law should be capable of guiding human conduct. Fuller emphasized that the 8 principles are neutral between a variety of substantive aims of the law. He called them the inner morality of law in order to contrast them with the external moral aims that the law may pursue. For example, the internal morality of law tells us nothing about whether the law should raise income tax or legalize assisted dying. Elsewhere in Fuller's writings, he added to these 8 principles another important element to the formal conception of the rule of law. This is the importance of access to courts. Jeremy Waldron develops this idea, explaining that it is an aspect of the rule of law which has been much neglected in academic commentary. Whilst lawyers have focused on aspects of the law itself, whether formal or substantive in nature, when lay people think of the law, they tend to think of the institutions and processes central to law's application, namely what courts do. To paraphrase Waldron, the rule of law is not just about rules, it is also about their impartial administration. This is not a novel development in theorizing the rule of law. Writing in the 19th century, Dicey places much emphasis on the normal operation of the ordinary courts, as he did on the characteristics of the norms that they administered. We must be careful, however, to see that it is important, what it is that is important about access to the courts. Dicey's view was that it was only traditional type common law courts which could satisfy this element of the rule of law. As a result, he strongly criticized the rise of administrative tribunals in the 20th century, which were established to hear appeals in the growing social welfare state. He argued that administrative tribunals always tend to exclude the jurisdiction of the ordinary law courts, and that they are never a completely independent tribunal, as they were staffed by government officials and therefore exposed to political bias. Whatever the flaws of their predecessors, in the UK, modern administrative tribunals are now staffed by judges with guaranteed security of tenure and play an essential role in securing access to justice, with relaxed rules of evidence and representation that increase their accessibility. For the rule of law, the important point is not access to courts per se, but access to an impartial system of adjudication. As Waldron puts it, what is required are institutions that apply norms and directives established in the name of the whole of society to individual cases, that settle disputes about the application of those norms, and that do so through the medium of hearings. Once Fuller's 8 principles are supplemented with access to such institutions, they form a cluster of ideas which have an underlying affinity and constitute together a viable conception of the rule of law. Against these more formal conceptions of the rule of law, a popular substantive conception of the rule of law is that offered by Lord Bingham. He argues the essence of the rule of law is that, quotes, all persons and authorities within the state, whether public or private, should be bound by and entitled to the benefit of laws publicly and prospectively promulgated and publicly administered by the courts. Thus stated, the principle seems to resonate with Fuller's conception. Lord Bingham elaborates on this notion through a set of principles, many of which overlap with Fuller's. But he also includes principles that Fuller would categorize as falling within the law's external aims, namely that the law must afford adequate protection for fundamental human rights, and that the state must comply with its obligations in international law. This division between formal and substantive categories is helpful to give a broad sense of the spectrum along which theories of the rule of law are ranged. In the context of the UK, I would argue that the appropriate version of the conception is, like Fuller's, more formal in nature. That is because of the strength of the democratic principle, reflected through the doctrine of the sovereignty of Parliament. It is not my place to offer a judgment on where the appropriate resting point should be for a society like that in New Zealand. However, I should say that I do not entirely accept the rather stark distinction drawn by Paul Craig, and this is for 3 reasons. First, as John Gardner argues, it is wrong to suggest that formal conceptions of the rule of law say nothing about the content of the law. One formal attribute is that the laws are sufficiently clear and intelligible. However, whether a law is clear and intelligible or not depends on the content of that law. If a law is unclear by, for example, stating that it is an offence to drive above a reasonable speed, the way to rectify this is to alter the content by being more specific, such that the law states an exact value, such as 70 miles per hour. Similarly, if a law is retrospective, then that is because its content is directed at the legality of something that took place in the past. That can be corrected by ensuring that its content is directed at the legality of things happening in the future, so that people have fair notice of their obligations at the time they act. Secondly, the rule of law is not a static ideal that perfectly obeys such a neat division. It cannot be universally applied without differentiation across all societies without regard to specific context. Precisely because it is constituted by a cluster of values, each of which is capable of being given greater or less prominence as part of the whole package, it is a concept that is flexible and attentive to local circumstances. Further, that group of values may be in tension with other values which are also essential in a liberal democracy, namely those which are constitutive of the democratic element and collective self-government. The relative weight given to these competing values may also vary, depending on the challenges faced by a particular society and background ideas of legitimacy which prevail in that society. Comparison of different states within the family of those which can be described as liberal democracies shows that different politics strike these balances in different ways. Also, it is possible for a polity to have a conception of the rule of law which is thick in some places and thin in others, depending on how ideas of legitimacy vary across the gamut of public decision-making. For example, in the UK, there is a strong emphasis placed on the need for the citizen to be able to have access to the courts to obtain justice, which feeds into a very strong presumption, to put it no higher, against interpretation of legislation which would prevent or impede that. But in other areas, for instance, in relation to social security benefits, there is a strong impulse to accept the determinations made by Parliament, even if they might be thought to be harsh. The third reason I question the starkness of the distinction is that it suggests that formal or thin doctrines of the rule of law are undemanding and anemic conceptions of the law. However, the principles expressed by Fuller place significant demands on lawmakers, and the fact is that many states around the world do not live up to them. Indeed, they are demands that all legal systems will fail to meet in some respects from time to time. Describing them as merely formal risks taking these principles for granted rather than regarding proper adherence to them as a matter requiring constant vigilance. The distinction might also be taken to suggest that only substantive conceptions result in substantive as opposed to merely procedural benefits. I would argue to the contrary, that adherence to the rule of law in its formal version provides significant substantive benefits in the economic, political, and moral domains. Starting with the first of these three domains, Max Weber explains that where the law satisfies the requirement that it be stable and predictable, this has significant economic benefits. If citizens can predict when the law will impact upon them and hence are enabled to plan their affairs, they can have confidence to invest for economic gain. Where the law defines and enforces property rights, it provides an answer to the tragedy of the commons. The owner of property can invest in its protection and development in the expectation that the fruits of this work will accrue to them. Furthermore, citizens can have confidence to trade with each other, knowing the state will enforce their contracts. As the economist Joseph Stiglitz points out, a capitalist economy depends critically on this aspect of the rule of law. Similarly, Weber ties the development of the rational bureaucratic state in the West as distinct from state forms based on legitimization through tradition or charismatic rule to the development of capitalism. The rational bureaucratic state allows for the calculability necessary for the accumulation of capital and capitalist economic planning and investment, whereas traditional forms of rule make the rule and administration of justice unpredictable. Capitalism needs reliable calculability, and the same could in fact also be said of other types of economic system, including our modern mixed economies, which are versions of democratic capitalism. It is these economic benefits that have led the World Bank to monitor the rule of law as one of its 6 governance indicators, using the index compiled by the World Justice Project. However, despite the obvious economic benefits of the rule of law, attempts at quantifying it and ranking countries by using it as a metric in relation to economic development should be viewed with circumspection. For a start, the rule of law is a multifaceted, qualitative ideal that makes for difficult economic quantification. Neil McCormick points to a tension between the rule of law as governance through predictable rules and the arguable character of law. Through our practice of contestation in court, it is always open to parties to present rival arguments about what the law is and how it applies to the facts. And as he says, quotes, a process of evaluating the relative strength of competing arguments is bound to be a matter of more or less, a matter of opinion, calling for judgment. The very practice of law has an effect of destabilizing it and making it less predictable. So what is required is not absolute predictability, but a sufficient level of predictability to give confidence to encourage people to engage in economic activity. Moreover, there is deep disagreement about what the rule of law entails, and this opens the door to the ideological manipulation of the ideal for other purposes. For example, an organization called the Center for Financial Stability has an index which includes as indicators the burden of government regulation, efficacy of corporate boards, and the strength of investor protections. This suggests the real aim of many of those ranking systems to be to persuade governments to adopt substantive content into their law, in particular laws protecting property rights and foreign investment. The extent to which a legal system should protect these matters is a subject of political contestation for good reason, as they require trade-offs with other aspects of the public interest. As Jeremy Waldron has argued, to say that the rule of law requires their maximization without qualification is a distortion. Instead, the formal conception of the rule of law's emphasis on predictability and stability has sufficient economic benefits without importing these contested substantive ideals. Turning from the economic to the political domain, the rule of law, as a constraint on government, limiting its discretionary powers and protecting against capriciousness, serves an important legitimating function for the exercise of public power. According to David Beetham in his book, The Legitimation of Power, power is regarded as legitimate when its exercise is subject to rules or principles. Acceptance by a ruler of limitations upon their power under a system of law can actually serve to increase that power by gaining the consent of their subjects to their rule. This argument is tellingly illustrated by the advice given to rulers in the 16th century by Jean Baudin, who is usually regarded as a theorist of unlimited sovereignty. In a real sense, when considering the generation of political authority and hence power, less is more. Political authority is a valuable commodity when one is seeking to achieve a well-ordered state. The legitimating aspect of the rule of law might in theory be attractive to a despot as well as to a democrat, but there is also a particular way in which a formal conception of the rule of law is needed and indeed central to democracy. In a democracy, the public as a collective seeks to achieve self-rule. This can only be done if their will is given a concrete expression through laws, which can be used to guide the conduct of the political community. It is the cluster of principles that constitute the rule of law which makes this possible. The requirement of generality ensures the laws apply equally to the public as a whole. The requirement of accessibility ensures that they are available to all. And the requirements of stability and certainty mean that the law is capable of guiding the community. This does not mean that democracy and the rule of law are the same thing. A democratically elected government and a legislature may depart from the rule of law in any number of ways, such as passing retrospective legislation or simply refusing to comply with the law at all. Developing this theme, Raymond Geuss argues that the component elements of liberal democracy involve internal contradictions and are in tension with each other. The rule of law is ultimately difficult to reconcile in full rigor with the discretion inhering in the executive and its ability to react speedily to events, which is an inevitable part of governing. These are not, therefore, elements which form part of the same concept. They support different claims and different values, and the balance between them is arrived at by compromise. The final benefit I wish to touch on is the moral value that is inherent in the formal conception of the rule of law. This might appear to be a contradiction in terms, However, Fuller emphasized that just because his vision of the law was neutral between some different moral aims of the law, this does not mean that it is completely morally neutral itself. There is a deep connection between the formal conception of law and respect for human agency. As Fuller put it, quotes, "To embark on the enterprise of subjecting human conduct to the governance of law involves of necessity a commitment to the view that man is or can become a responsible agent, capable of understanding and following law, and answerable for his defaults. Every departure from the principles of the law's inner morality is an affront to man's dignity as a responsible agent." The dignity-enhancing aspect of the rule of law is also a theme picked up by Jeremy Waldron. For Waldron, dignity is the status of a person predicated on the fact that she is recognized as having the ability to control and regulate her actions in accordance with her own apprehension of norms and reasons that apply to her. Whilst many theorists focus on the law's coercive power, in reality, law mostly operates through what Henry Hart and Albert Sachs called self-application. People applying officially promulgated norms to their own conduct rather than waiting for executive intervention from the state. In this way, the formal conception of the rule of law presupposes a commitment to the dignity of human beings as rational agents. To sum up, here is Neil McCormack again. Quotes, "The rule of law is a possible condition to be achieved under human governments. Among the values that it can secure, none is more important than legal certainty, except perhaps its stablemates, security of legal expectations, and safety of the citizen from arbitrary interference by governments and their agents. For a society that achieves legal certainty and legal security enables its citizens to live autonomous lives in circumstances of mutual trust." If a formal conception of the rule of law already gives us these benefits, why should we adopt a more substantive one? As I have indicated, Lord Bingham defended a conception of the rule of law that included the full range of human rights, including the right to privacy, family life, and freedom of expression. Lord Bingham's argument for this was that there are some practices so abhorrent as not to be tolerable, and that a state which departs from these human rights should not be given the ennobling and legitimating accolade that it accords to the rule of law. The argument explains why human rights should be protected in every country, but it does nothing to explain why this is itself required by the rule of law as a concept. As John Gardner points out, Lord Bingham is making the following invalid argument. Conformity with the rule of law is a hallmark of civilization. Human rights are also a hallmark of civilization. Therefore, human rights are part of conformity with the rule of law. I should emphasize at this point that to say that the concept of the rule of law does not include human rights or democracy in no way diminishes the importance of these values. We live in a world in which value pluralism obtains, meaning that there are numerous and irreducible moral values. The rule of law, human rights, and democracy are each themselves basic values or clusters of values which cannot be reduced into one another, and we should not seek to unite them by searching for an overarching common metric. Since the rule of law attracts near universal affirmation, there is a temptation to seek to inflate the concept so as to include ideas that are more contested. This is the maneuver of the Centre for Financial Stability's Rule of Law Index I mentioned earlier, which seeks to incorporate protection for foreign investment under the guise of the rule of law. John Tasioulas rightly argues that there are good reasons why we should take care to resist this temptation to inflate the concept in this way. The danger of this sort of conceptual overreach is that we lose sight of the distinctive idea conveyed by a given concept through its conflation with quite separate ideas, obscuring the fact that all these distinct ideas identify distinct values which we must deliberate over and balance through compromise. There is a tendency in legal and political theory to attempt to shortcut this process of compromise in order to assert a consensus, which is in fact illusory. Importing ideals which are subject to significant contestation into the concept of the rule of law is an example of this. However, as Bernard Crick writes in his book, In Defense of Politics, consensus will always be elusive in modern multicultural societies with diverse values and beliefs. Legitimacy in such societies is not maintained by the achievement of consensus, but by procedures that enable all parts of society to engage in political deliberation, such that the losing party believes that the outcome is legitimate, even if they believe it is wrong. Inflating the concept of the rule of law conceals the underlying conflicts and hinders thoughtful debate about the trade-offs which are required. One of these conflicts is between democracy and the rule of law. In some instances, rule of law principles may have to give way to these other values to secure what is good in them. A recent example is the law passed in the United Kingdom, pardoning gay men who were convicted for consensual sex under previous criminal legislation, now repealed. Whilst this technically breaches the rule of law principle against retrospectivity, a democratically elected parliament, representing the changed morals of the political community, has weighed these different values and decided that the rights of these men outweigh such considerations. Similarly, there are tensions and conflicts within the cluster of ideas which constitute the notion of the rule of law. For example, there may be a tension between the principles of certainty and accessibility. A statute may use simple, untechnical language that can be understood by any lay reader, thus promoting accessibility. But this may in fact produce results which are excessively crude and unjust, making it uncertain whether a court will actually apply the statute in that way. The legislature may seek to remediate such potential injustice by introducing complex qualifications to the apparently clear statement of the rules, perhaps by employing supplementary definitions in schedules, cross-references to other legislation, and so on. And this may make the meaning of the legislation more certain, but at the same time, less accessible. If we attempt to sidestep the conflicts of values which occur within the rule of law idea, and those which arise between the rule of law and other values by concealing them through use of an expanded definition of the rule of law, we undermine our ability to engage in deliberation about how we should resolve these conflicts. The denial that there are such conflicts is associated with a form of elite managerial politics, which may be felt to be deeply frustrating for those who do not accept the consensus, and may serve, in fact, to make political modes of accommodating the tensions more difficult. Contestation within a democratic framework is healthy, rather than something to be avoided at all costs. My final reason for taking care with what goes into our conception of the rule of law is that, particularly in legal systems with unwritten constitutions such as ours, importing greater substantive content into the rule of law has consequences for the balance of power between the courts and other branches of the state. And this is a theme I wish to take up in addressing the second question of why the rule of law matters. So far, I've been discussing the rule of law mostly through the lens of scholarly commentary. But the rule of law is not just an abstract principle debated in university philosophy departments. In the UK and New Zealand, it is a constitutional principle that animates our unwritten constitutions. The courts in both jurisdictions employ the language of the rule of law to legitimize and explain their constitutional role, and also the constitutional roles of other branches of the state. In the UK, in the first Miller case, the UK Supreme Court stated that the role of the judiciary is to uphold and further the rule of law. Similarly, in Tannadice Investments Limited and Commissioner of Inland Revenue, the New Zealand Supreme Court said that our constitutional arrangements recognise that the Parliament of New Zealand is the supreme lawmaker. The courts of higher jurisdiction, however, have constitutional responsibility for upholding the values which constitute the rule of law. Therefore, the idea of the rule of law is capable of having significant implications for how the judiciary decides real cases before the courts. The more substantive the idea is taken to be, the greater the role claimed for the courts. The more procedural, the more constrained the role of the courts when interacting with other branches of the state. And I will now consider a few examples from case law. The Unison case in the United Kingdom concerned the level of fees set in relation to bringing a claim in employment tribunals to vindicate rights of employees, including the low-paid and those who have lost their jobs. For a long time, no fees had to be paid in order to lodge a claim, so as to secure access to justice for such people. But the statute of 2007 gave the Lord Chancellor a power to impose fees. And in 2013, the Lord Chancellor exercised this power to make an order requiring fees to be paid in respect of any claim brought in an employment tribunal. As a result, there was a substantial drop in claims. The trade union, Unison, sought judicial review of the order on the basis that it was ultra vires the statutory power. The Supreme Court held that the order was ultra vires and quashed it. The court held that in determining the ambit of such a power, the court must consider not only the text of that provision, but also the constitutional principles which underlie the text. The relevant principle was the rule of law because the constitutional right of access to the courts is inherent in the rule of law. There is also a connection between the rule of law and democracy. Lord Reid explained, quotes, "Courts exist in order to ensure that the laws made by Parliament and the common law created by the courts themselves are applied and enforced. In order for the courts to perform that role, people must in principle have unimpeded access to them. Without such access, laws are liable to become a dead letter. The work done by Parliament may be rendered nugatory, and the democratic election of members of Parliament may become a meaningless charade. That is why the courts do not merely provide a public service like any other." The statutory power could not be exercised in a manner that was incompatible with the fundamental principle of access to justice. This shows how the connection between the rule of law and democracy is not merely theoretical, but is used as an interpretive tool to place constraints on the manner in which the executive may use a discretionary power delegated to it by Parliament. The importance of the rule of law can also be seen in New Zealand jurisprudence. In Attorney General and Chapman, the question was whether so-called Bayesian damages were available for judicial breach of the Bill of Rights Act 1990. The Supreme Court split 3-2, with the majority holding that such damages were only available against the executive and not the judiciary. The difference between the majority and minority was due to the fact that the case raises a conflict between two different principles within the rule of law. On the one hand, the majority emphasized the need to protect the independence of the judiciary, which is a core aspect of the rule of law. On the other hand, the minority gave greater weight to the rule of law principle that violation of rights requires a remedy. Reliance was placed on Lord Cooke's statement in Darker and Chief Constable of the West Midlands Police that immunities from suit are in principle inconsistent with the rule of law. Chapman illustrates the underlying conflicts of value within the rule of law. The two values, judicial independence and vindication of rights, are incommensurable. They represent distinct values which cannot be elided into one another. To resolve the conflict, the Supreme Court had to engage in the familiar process of common law reasoning, whereby competing interests are weighed up and balanced to determine the precise content of the rule to be applied. The line of case law on ouster clauses illustrates the conflict of the rule of law with other constitutional principles, in particular parliamentary sovereignty and the democratic principle. The Annes Minute case concerns review of a decision of the Foreign Compensation Commission, which had been established to distribute compensation given by the Egyptian government to the UK government for British properties it had nationalised. Annes Minute's claim for compensation had been refused on the grounds that their successors in title did not have British nationality, which the Commission considered was required by the compensation scheme. Annes Minute sought judicial review, but ran up against the clause providing that, quotes, "the determination by the Commission of any application made to them under the relevant Act shall not be called in question in any court of law." The House of Lords held that this did not prevent judicial review in this case, as the clause would only be effective to oust review of errors made within jurisdiction. Lord Pearce explained that the more reasonable and logical construction of the clause was that by determination, Parliament meant a real determination, not a purported determination, and a decision made without jurisdiction would be a purported determination falling outside the ouster clause. The Commission had made an error in construing the Act, and this meant that the decision was made without jurisdiction. Annes Minute was applied in New Zealand in the bulk gas users group case, another leading judgment of Lord Cooke. He held that the relevant ouster provision does not apply if the decision results from an error on a question of law which the authority is not empowered to decide conclusively. Neither Annes Minute nor bulk gas users group mentioned the rule of law or parliamentary sovereignty. Instead, they focused on technical concepts of jurisdiction. However, gradually the courts have moved away from a jurisdictional analysis to analyse this sort of case by recourse to underlying constitutional principles. This is seen most clearly in the Privacy International case in the United Kingdom. The claimant sought judicial review of a decision of the Investigatory Powers Tribunal in relation to alleged wrongdoing by the UK's intelligence agencies in relation to computer hacking in respect of certain classes of people. An ouster clause in section 67(8) of the Regulation of Investigatory Powers Act appeared to prevent such a claim. The clause provided that, except to such extent as the Secretary of State might by order provide, quotes, determinations, awards, orders, and other decisions of the tribunal, including decisions as to whether they have jurisdiction, shall not be subject to appeal or be liable to be questioned in any court, close quotes. Since the discretionary power in section 67(8) to provide for appeals had not been exercised, decisions by the tribunal would be legally invulnerable absent judicial review. The question was whether, properly construed, the legislation ousted the court's judicial review jurisdiction. In the Court of Appeal, I gave the lead judgment. I acknowledged that the court adopts a highly restrictive approach to the interpretation of ouster clauses, reflecting the fundamental importance of the rule of law in our legal and political system. However, I concluded that the case turned on a short point of statutory construction, and that on its proper construction, section 67(8) did clearly mean that all determinations, awards, orders, and decisions of the tribunal shall not be liable to be questioned in any court. I took into account a number of considerations. Section 67(8) referred not only to determinations, as in Allen's Minnick, but also to decisions as to whether the tribunal has jurisdiction. The quality of the membership of the tribunal, which was headed by a High Court judge, was very high in terms of judicial expertise and independence, suggesting that Parliament really did intend that it should be in a position to make final determinations on issues of law. Also, Parliament had created the tribunal to deal with the special problem of determining claims against the intelligence services, which requires the use of closed material procedures to guarantee maintenance of the confidentiality of secret information on national security grounds, a guarantee which would not apply in ordinary judicial review proceedings. The Supreme Court allowed the appeal, disagreeing with this analysis by a majority of 4-3. The two judgments given by the majority relied on different reasoning, as did the two judgments given by the minority. These judgments contain a rich discussion of the tensions between the values of the rule of law, democracy, and parliamentary sovereignty. The conflict identified was that, on the one hand, the rule of law requires maintaining access to the courts to challenge unlawfulness, whilst on the other, democracy and parliamentary sovereignty require effect to be given to the clear words used by the legislature. Lord Sumption, in the minority, identified two main ways that this conflict can be resolved, which can be used to frame the different judgments. The first, radical or normative view, is to hold that the rule of law means that Parliament is subject to a higher law as ascertained and applied by the court. On the radical view, the conflict should be resolved in favour of access to the courts, since the rule of law is a constitutional principle that is so fundamental that it takes precedence over parliamentary sovereignty. The possibility of the radical view was countenanced decades earlier, in 1986, by Lord Cooke in extrajudicial writing, when he said, "We are on the brink of open recognition of a fundamental rule of our mainly unwritten constitution, namely, that determination of questions of law is always the responsibility of the courts of general jurisdiction." Such a possibility was also referred to in dicta of some of the judges in the Jackson case in the UK on the fox hunting legislation. Lord Hope referred to the rule of law as the ultimate controlling factor of the Constitution. Baroness Hale referred to possible qualifications on parliamentary sovereignty, and Lord Steyne considered that there might be fundamental principles of the Constitution which no Parliament could abrogate. The radical view about a rule of law qualification of parliamentary sovereignty was not expressly endorsed by any of the members of the court in Privacy International. Lord Carnworth stated that the court was not addressing the difficult constitutional issues which might arise if Parliament were to pass legislation purporting to abrogate or derogate from the rule of law. Lord Sumption explicitly rejected the radical view. He held that the rule of law applies as much to the courts as it does to anyone else, and under our constitution, that requires that effect must be given to parliamentary legislation. In other words, since Parliament has authority to make law, the principle of the rule of law requires that courts should respect and give effect to any law so made. Lord Sumption, in the minority, again, I remind you, also articulated an alternative, less radical and conceptual way of resolving the conflict, which is to argue that judicial review is necessary to sustain parliamentary sovereignty, because Parliament's ability to legislate depends on the existence of independent courts to interpret and give effect to its legislation. This was a view previously suggested by Lord Justice Laws in the Court of Appeal in the Cart case. The less radical view received more support in Privacy International. Lord Sumption stated that he would accept it up to a point. He reasoned that the only way in which a proposition can have effect in law is for it to be recognised and applied by the courts. However, in his view, there was no conceptual difficulty with Parliament being able to create a body of unlimited jurisdiction that was not subject to judicial review at all, albeit it would be an unusual thing to do. In his view, the conceptual question did not in any event arise, as Section 67(8) was not a complete ouster. It only prevented review of a decision of the tribunal on the merits and did not exclude review to enforce the statutory limits on the tribunal's powers or subject matter competence, or the statutory and other rules of law regarding its constitution. Lord Wilson, giving the other minority judgment, expressly accepted the conceptual impossibility of a complete exclusion of review, but considered it did not arise in this case. In the majority, Lord Lloyd-Jones expressed support for the conceptual approach of Lord Justice Laws that, quote, "It is a necessary corollary of the sovereignty of Parliament that there should exist an authoritative and independent body which can interpret and mediate legislation made by Parliament," close quotes, although he accepted that this role could be performed by judicial bodies other than the High Court. Lord Calmworth also defended the conceptual approach, holding that it would be a contradiction for Parliament to entrust a statutory decision-making process to a particular body, but then leave it free to disregard the essential requirements laid down by the rule of law for such a process to be effective. In my view, it is true that the rule of law ordinarily supports parliamentary sovereignty by ensuring that there are independent courts to give effect to its legislation. But I think it may be a step too far to say that this is such an essential part of parliamentary sovereignty at a conceptual level that it is unable to exclude access to the courts in appropriate circumstances. The reasoning seems to overlook the fact that Parliament exists in time and in successive instantiations, rather than as a single unchanging institution. Parliamentary sovereignty, that is the power to choose what laws to make, attaches to each successive Parliament. This seems to entail that, in principle, a later Parliament can choose to exercise its sovereignty to abrogate access to the courts in relation to rights created by an earlier Parliament. Parliamentary sovereignty is unrestricted. The earlier Parliament does not have constitutional authority to immunise the rights it creates by its legislation from interference by a later Parliament exercising its own sovereignty. Since the earlier Parliament cannot do that expressly, it is difficult to see how such an effect can be spun out by implication from the notion of parliamentary sovereignty, which is what confers on the later Parliament the authority to decide for itself what effects to provide for by its legislation. It is the case that there is a very powerful presumption against ouster of the right of access to the courts, but it is not irrebuttable on grounds of supposed conceptual limits to be spelled out of the principle of parliamentary sovereignty itself. I would express it in the following way. There is a principle of comity that operates between earlier parliaments and later parliaments. This comity means that later parliaments are presumptively taken to intend that rights set out in legislation of an earlier parliament should be capable of vindication by bringing proceedings in a court. This falls within the principle of legality, namely a principled presumptive commitment by the legislators to certain basic principles which can be viewed as underpinning a liberal democracy committed to the rule of law. In other words, the legislators in later parliaments are presumed to respect the availability of access to the courts to vindicate rights which have been enacted by earlier parliaments. However, This is a presumption that can be rebutted, where it is sufficiently clear that Parliament has clearly considered the issue and has decided that the circumstances warrant creating a body immune from review. What words or other context would make that sufficiently clear is something that, as a sitting judge, I will not venture to consider. Privacy International represents the high watermark of judicial consideration of ouster clauses in the UK. As for New Zealand, Philip Joseph suggests that the New Zealand courts have charted something of a middle path with ouster clauses. In Tannadice Investments, the New Zealand Supreme Court recognises that the constitutional principle of the rule of law meant that the courts would be slow to conclude that review had been ousted. However, this was weakened where Parliament had created a sophisticated system of appeals which provided adequate protection against unlawful decisions and rendered judicial review unnecessary. A similar approach has been taken towards partial ouster clauses for decisions of the Employment Tribunal, which the New Zealand courts have held successfully exclude review for breach of natural justice or error of law. On the other hand, in Ortman and United States of America, the Supreme Court held that the more limited rights of appeal under the Extradition Act 1999 did not oust judicial review. But the court was clear that this did not rest on an absolute prohibition against ouster clauses that stemmed from the approach in Annis Minnick. The court noted that Annis Minnick had been followed by the UK Supreme Court in Privacy International, but stated that the theory of absolute invalidity of an order made ultra vires, on which Annis Minnick rested, had been eschewed in New Zealand. Instead, the focus of the court's analysis was on the legislative scheme, and it concluded that this scheme showed that review was not intended to be excluded. And this strikes me as a sophisticated and principled approach, and one which, in the spirit of Lord Cooke, the common law world could learn from. Returning back to the second question of my lecture, these cases show how the idea of the rule of law can at times play a decisive role in court rulings both in the UK and in New Zealand. They've also illustrated the tensions between the different aspects of the rule of law and between the rule of law and other constitutional principles. These tensions demonstrate the need for careful analysis of what does and does not form part of the relevant concept of the rule of law. I wish to conclude by very briefly acknowledging some of the rule of law issues that are currently being considered in New Zealand. As a foreign judge, I can only comment on them at a very high level of generality. Justice Glazebrook has made the case in the speech with the title, The Rule of Law, Guiding Principle or Catchphrase, for a substantive conception of the rule of law in the New Zealand context, including the principles of the Treaty of Waitangi and Maori customary law Tikanga. The role of the treaty principles, which Lord Cooke played a significant part in developing, is currently the subject, I know, of a controversial bill before your Parliament. As someone from outside New Zealand society, it's not appropriate for me to attempt to enter into this area of debate. I acknowledge that Justice Glazebrook's more substantive conception of the rule of law is different from the more formal one I have set out to defend this evening. But as I have sought to explain, each individual polity inherits and creates its own legal and political culture. The boundaries of the concept of the rule of law are a function of that culture and are not fixed a priori. Moreover, as Jeremy Waldron observes, by deploying subtly or considerably different conceptions of the rule of law against each other, we lay the conditions for each conception to be enriched by elements that are not initially given as part of its content. Also, as I have emphasized, the concept of the rule of law does not occupy the whole field of what is valuable in political and legal life. To say that some principle of law has value does not mean that it necessarily has to have that value by virtue of the concept of the rule of law. There are other values which, living in a democracy, we may deliberately use the law to pursue. Democratic self-determination for a society requires contestation. At its best, one hopes that this can be honest and respectful. It is better to embrace contestation as part of the vibrant life of society and not as something to be suppressed or denied. As the great New Zealand historian J.G.A. Pocock observed in his book of essays, The Discovery of Islands, a political society is one that, quotes, constructs a history of itself that is contestable and contested. including contested accounts of what political authority has been and should be, and of how history has been and should be written in the ongoing context of a society's debate with itself as to what it is, has been, and ought to be. The political structure which enables a society to contain its self-contestations and continue its history may be described in terms which combine and offer to reconcile the notions of authority and liberty. Ex imperio libertas, in the words of an ancient Roman. We are free because we possess authority exercised over ourselves and over others, which we use to determine what we are and shall be. Thank you.
I've just made an executive decision that we will have questions at drinks. It's very hot in here, and I think it's time for people to have a drink. But before then, I have to fulfill my obligation to do the vote of thanks. So for those of you who don't know me, I'm Jeff McClay, and it's my honour tonight to speak on behalf of my colleagues to thank Lord Sales, to thank the Cooke family, and I want to say a couple of other things. You'll be shocked about the law school and the university. And I want to finish with some closing words at the end of this year. But the first thing I'd like to do is to acknowledge, as has already been done by Bryony and by Lord Sales, those who have passed. These are annual lectures. And one of the things that I notice when I come to them is not only the faces that fortunately are still coming and continue to come, but also the faces that aren't coming anymore. And I just want to, and this is the last time I have to do this year, to acknowledge that one of those faces tonight is my own father, who died earlier in the year. Let's acknowledge his cousin, my cousin David. I said you have to let everybody who has a McClay in their surname into the main lecture theatre. But I just wanted to acknowledge my father, because he would have come to probably between 15 and 20 of these lectures over the last few years. He was also, like many fathers, insufferably proud of his sons when talking to other people. And I just want to acknowledge that I miss him here tonight in his ridiculous Stewart of Appin tie, which I'm sure he would have been wearing. I also want to feel my obligation to thank Lord Sales and his wife for making the incredible journey to New Zealand. I haven't quite verified this, but I understood that they even did the most extraordinary thing of travelling to Wellington by train. Once they had flown to New Zealand, they didn't take the train quite all the way from London. But many of us have not been quite so brave, I suspect. So I thank you for your intrepidness, both in the length of your journey and in doing something that many of us would have warned you deeply against. I also just want to acknowledge the topic. I feel incompetent to comment on this comment for a number of reasons. For many years, I have turned up at conferences around the world, and I think I've disappointed them because I always think that they're expecting another Jeffrey from Wellington. And that Jeffrey from Wellington is much more definite than I am. He's a little less softly spoken, and he's actually far more interested and accomplished than I will ever be. So, and I'm sure on this particular topic he would have much to say. I also just acknowledge my general competency in public law. Dean was in the back there nodding at many of the cases in a knowing fashion, and I was just wondering, how do I make this up? And in particular, I just acknowledge my actual track record in the rule of law, because once upon a time I was very proudly appointed to the Law Society's Rule of Law Committee, which very, very soon after was abolished. And while I have been assured that correlation is not causation, I think people in this room know otherwise. So I would just state the following observations about the talk. I won't comment on the specifics. You can ask His Lordship, Philip, after at drinks about the specifics. I'm sure Dean, in his knowing way, will have questions to ask, and I know many others will. But when I was sitting there, it reminded me of the debates that we also have in New Zealand about the nature of the common law itself, that the rule of law and the common law often suffer from both overclaiming and underclaiming, that people often want the common law to be everything, and sometimes they want it to be nothing. And sometimes I think in the debates that I've seen in New Zealand, we have the same issue going on, that we either overclaim or we underclaim, that we want to say the rule of law is the things we want it to be, but rather than perhaps the things it needs to be. And I think today's lecture is a perfect illustration of why it's important to be careful about concepts, that it's okay if something doesn't do everything you need in life. It's okay if the common law is not just and fair, to disappoint your father, I suspect. It's okay if you need to do other things to make the world a better place than rely on some 19th century case. In the same way, I think we need to acknowledge that some of the current debates about the rule of law are mired in a legitimate desire to make it more than it is. And I say this from both sides of the political spectrum, because like many things in our world, these concepts have become somewhat weaponized in a way that is deeply unhelpful to our understanding of the way we need to live together, particularly on these islands. It's not that we can't argue about what the law is or what the law should be or what democracy requires us to do or not, or what we should respect. It's just that they aren't predetermined by some kind of concept or some kind of mantra. In my world, the common law, or in what Philip has described as the rule of law. It's okay if something doesn't cover everything. And that's what I'll take from tonight's lecture, that one can look at concepts both from a lawyer's perspective and from a philosophical perspective, because it's important to do that and not expect the world to be simply reduced to slogans, which I fear on both sides of the debate in New Zealand at the moment, the rule of law is being somewhat confined to. I want, before I get to the last vote of thanks, to say something about the university and this law faculty. The first thing I wanted to say is that I wanted my cunning plan to get the provost here was not for her to declare the everlasting independence of the law faculty, but actually to acknowledge Bryony and also Nick, our vice-chancellor, because I have been asked constantly who would ever want to be a dean. And my job is actually really easy, because all I do is I just say how great my staff is, or how great our staff is, and how great our students are. That's generally all I do in my meet, right? Yeah. But Bryony actually has to say no occasionally. And I would just like to say that while it's not entirely true she has given me everything I've claimed I've needed, she has given this faculty a substantial amount of what I've said we've needed over the last 6 months. So I thank her for that, and I also thank her for the support that she has given me. I also want to say something about the law school, that I'm deeply honoured to be in charge of the thing in the world that, apart from my family and my friends, I probably somewhat tragically love the most. And I was trying to explain why that could be, and then I was at, as some people in this room were, at the most wonderful ceremony last Friday morning. The university has just reawoken our marae and importantly opened the fabulous Ngā Mokopuna building. And some of you might not know what these things are. When I went to university, I didn't know where the marae was. I'm sorry, Joe. And I went there the year after it opened. But one of the things that struck me about those ceremonies was what was really important. What makes those buildings beautiful is not just the fact that they are physically attractive, and the new building is as attractive as the Whare Nui is. It's beautiful. You should go there. It is an architectural jewel. Absolutely right. But that's not what really makes it beautiful. What makes it beautiful is that it reflects a collective act of will to do something that nobody else thought could be done, and I fear done in the teeth of some opposition and indifference, and I fear even some hostility. And it would be impossible now to imagine our university without the new reawakened Te Hunga Waka. During the ceremonies, one of the kaumatu, in the only language unfortunately I can really understand, spoke of the reason why he was so proud to be there. And his words were, and I think of the law school like this too, the people that built this marae imagined something that we could not dream. Because when he went to university, this kaumātua described, there were almost no Maori students. And we would have seen, and Barney saw, and just as Joe saw, and the others who were there saw, so many Maori students, and so many in the Kapahaka group, so many law students. And that's an extraordinary thing. This kaumātua said, the people that built this marae imagined what I could not dream. And I just want to leave you with that thought about the role of this law faculty, because that's one of the privileges of working here, is that I work constantly with people who imagine things that I cannot dream. And I tell my students, and they always surprise me, that they are the people who are doing the imagining of the things that I cannot dream. And that is the honour of a lifetime, to be involved with working with those people and with being able to teach those people. So I thank you for all of that. My third vote of thanks, I'm sorry, I'm taking a long time. I did warn him that I want to say something about the university. I just want to thank everybody in this room and the room across the way, because in many ways, none of that would be possible without many of the people in this room. Be you my colleagues, and I'll talk about them particularly, but also some of our supporters. One of the things we really want to do in the new year, once I've had a bit of a sleep, is to make better use of the community in which we exist, because I think our strength comes from that great community. So I thank you and acknowledge all of you for coming tonight and for being part of the thing that makes my great job really possible. I also just want to pay particular tribute to my colleagues. This has, as the Provost has alluded to, been a difficult year. It has been a much less difficult year than I feared at the beginning, because of the strength and resilience of the colleagues who I'm lucky enough to share this building with. My ambition was for the lights not to be turned off at 8 o'clock on the Thursday, whatever it is today. But my colleagues have done and surpassed that. A high-ranking judicial figure once said to me when I was explaining how my job at the Law Commission was to do no wrong, he said, that's a very sad view of life. You should try and do much better than that, Jeff. And my colleagues have done much, much better than that this year. So what I wanted to do was to end with some words, and I can't really think of any words to end this year. So I keep on coming back to the words from where I come, that I come from the whenua o Ngāti Tauranga Tira. These are not secret words. These are words that every New Zealander knows. I suspect even our English visitors know. These are words that were spoken so strongly a couple of weeks ago outside our building. These are words that most importantly will be spoken or chanted tomorrow in the marae, where one of our students graduates, who these words properly belong to. I'm just going to steal them for a couple of minutes. So the words, of course, I'm referring to are Te Rauparaha's words. When I grew up, Tēngiahata, and Te Rauparaha are legends, particularly Te Rauparaha. And I know in other parts of New Zealand, he's a little less of a legend, and a little less well thought of, probably for some fair enough reasons, if you ask him. But Te Rauparaha is famous, of course, for the words that we all as New Zealanders know and we can all say, even if we don't quite know the story behind them. I'm not going to tell you all of that story now, because it's not really my story to tell. But those are the words of the spear, kāmati, kāmati. They are words of survival, kaora, kaora. They are also words, and most importantly, words of challenge, as we saw outside our building. They are words of rebirth and reimagining. Upane ka upane whiti te rā. So what I wanted to say at the end of this lecture, at the end of this year, is to say thank you all for keeping a little bit of the sun shining in this faculty. And now, with great pleasure, I say it is summer and you can go and have a drink.